A dismissal for a health and safety reason will be an automatic unfair dismissal, which has important consequences. Generally, for ordinary unfair dismissal, an employer needs to show that there was a fair reason for dismissal, and the employment tribunal also needs to establish that the employer acted reasonably, meaning that a fair process was followed. The reasonableness test has no relevance to automatic unfair dismissal cases, such as a dismissal for a health and safety reason, and the dismissal is automatically unfair. Generally, employees need to have at least 2 years continuous service with their employer to be able to bring an unfair dismissal claim. In certain cases, such as a dismissal for a health and safety reason, no qualifying period is necessary. An employee shall be deemed to be unfairly dismissed if the reason for the dismissal was that the employee had been carrying out or proposing to carry out activities designated by the employer in connection with preventing or reducing risks to health and safety at work. Or the reason for the dismissal was that the employee was a workplace health and safety representative or a member of a workplace health and safety committee. Or the reason for the dismissal is that where there was no such representative or safety committee, or it was not reasonable to raise by those means, the employee brought to the employer's attention circumstances connected with their work which the employee reasonably believed were harmful or potentially harmful to health and safety. Or the reason for the dismissal is that in circumstances of danger which the employee reasonably believed to be serious and imminent, the employee left or proposed to leave or refused to return to their place of work. Or the reason for the dismissal is that in circumstances of danger which the employee reasonably believed to be serious and imminent, the employee took or proposed to take appropriate steps to protect themselves or other persons from the danger. The maximum compensatory cap for unfair dismissal does not apply to dismissals for health and safety reasons. Before bringing a claim for unfair dismissal, you would need to follow ACAS's, that's the Advisory Conciliation and Arbitration Services, early conciliation process. Any claim for unfair dismissal must usually be filed within 3 months, less a day from when the employment ends, and that's subject to the rules for extending time for early conciliation. For more information, do visit my website. And remember that this video is for guidance only and should not be relied upon for specific advice. Also, the law can change. And also, don't forget to subscribe to my channel for updates.